Alright, so hello, thank you so much for coming today. Perhaps we could start with a brief introduction of yourselves. What practice area you're in, what are your interests? Okay. Yeah, a bit more about yourself.
We weren't warned we'd have to tell anyone about our interests. Shall I go first?
Yeah.
So, morning everyone. It's great to see such a big turnout. Everyone looking very smart on a Saturday morning. Excuse my casual appearance. I'm Justin D'Agostino, and I head up the international arbitration practice for Herbert Smith, now Herbert Smith Freehills, since we've also merged with an Australian firm in the last couple of months. And I head up our international arbitration practice for China. So I look after the teams in Beijing, Shanghai, and Hong Kong. And my practice is pretty much 100% disputes and 100% international arbitration. That takes two forms. General commercial arbitration, where we're acting for one corporate that has a dispute with another corporate. But also I do quite a lot of public international law work. So acting for or against states who also get themselves into disputes. So I do quite a lot of that work as well. But unfortunately, I'm the kind of lawyer, unlike Joseph, I'm the kind of lawyer that clients don't want to see because it means they've got a problem. But I try and get them out of that problem. Interests, I don't have time for any interests, I work too hard. But as you can tell, I like to eat. That wasn't meant to get a laugh, it was meant to anyway. I like to eat. My surname is D'Agostino, which is Italian. I know I don't look Italian, but my family's Italian, so Scottish Italian. It's a good mix. It means they like to eat and drink. So I live up to my name, my family.
Thank you. Catherine, would you
Hi, I'm Catherine Zheng. I'm from Deacons. I'm a partner at the IP practice. I actually specialize in China IP practice. My background is actually, I'm a mainland Chinese. I grew up in Shanghai. I went to law school in Fudan University. Then I actually went abroad and studied for a long time. I was living in Toronto, Halifax, and Ottawa, and worked there, studied there for about 9 years. So I was actually, I did my science degree in chemistry, then I went to law school again in Canada, so I was actually meant to be an IP lawyer because I'm so focused on IP-related areas. So because my background in China as well, so I decided to come to Hong Kong, which is really a place where I can use my legal education in China and in Canada as well. So I've been here for 12 years. I enjoy living in Hong Kong and working in Hong Kong. I have my family now in Hong Kong, so that's why I can't leave Hong Kong anymore. In terms of my hobby, I see a lot of girls as well. 20 years ago, I was just like you guys, sitting down there. But now I have a family with 2 kids, so if you want to ask me anything about female lawyers having kids, I can share with your views. I think that's it for me.
Thank you.
Hi, good morning everyone. The second time, I have you good morning. Rico Chen, partner of McKenzie. I head up the real estate practice group of our firm in Hong Kong, China. And by way of background, I'm very much a Hong Kong person. I studied law in Hong Kong, work in Hong Kong. Other than the 4 years I lived in Beijing as a resident partner of our Beijing office, my practice has been in Hong Kong, but is I would say 110% China focus. So echoing what Joseph said, at the time when I joined the firm because I wanted to join the China practice of the firm. So at that time, like when Joseph was joining the national firm, I saw not a lot of people were doing that. But at that time, I would say that it seemed quite interesting as a trend. So over the years, I never regretted. I think because I did have a kind of interest about China development, and China as a legal system presents you with a lot of challenges, ambiguities, headaches, but a lot of you're involved in system and how looking back when on my first negotiation back in 1990 or 1991, and now when you're going to China to negotiate something across the table, you look how things have changed and improved. You feel really good about it, and you have seen all the improvement that have been coming. Of course, there are some, as I said before, there have been some setbacks, by and large. The developments have been very positive. I feel that it has been a very good journey to be part of that. And interest, I like to work, and I like reading, a little bit of sport, like sports, eating, of course. I like other people too.
Thank you very much. Picking up on your point of China being a very vague system, do you think that might be a major disincentive for foreign companies in investing in China in perhaps your respective areas? I'm sure there are regulations maybe a bit vague in each of your different areas.
I think it's a big issue. I think if you're a foreign investor coming from Europe or from the United States, you are nervous investing in China. That's the starting point, because you don't know what to expect. You maybe have heard a lot of horror stories about investments going wrong, people losing their money, people not being maybe treated fairly, they feel, by the counterparty. Big cultural differences. So I think investors do come to investing in China with nerves, but they don't have any choice, because they have to come to China. This is the place to be. Everybody has to do deals with China. So you have to work your way around it, and that's actually a big bit of my job, which is advising clients on how to mitigate the risks of doing investments with Chinese parties. I mean, more and more I'm actually acting for the Chinese, because the Chinese now are the ones investing all over the world. So last year the figure was something like $70 billion US was invested by China abroad. Most of that into Australia, one of the big reasons for our merger. This year, most of the investments going into South America. And actually, when I'm talking now to Chinese clients, those same nerves that the foreigners have had when they've been coming into China, those same nerves are being felt by the Chinese. So my Chinese clients are saying, but if I'm going into Africa, what do I expect? How do I mitigate my risks? So it's actually both sides of the coin. Everyone's nervous about doing business in a new jurisdiction, and that's kind of the key. If you go somewhere new, you don't know what to expect, and that's why you need good lawyers to help guide you through it. So one of the things that I do, and it's particularly pertinent to my practice, is most of these cross-border transactions, you will find arbitration clauses in those contracts. And why is that? It's quite simple. If you are, let's just do the inbound stuff. If you are a European or an American or an Australian investor or somebody doing a deal with the Chinese, you do not want to find yourself in the Chinese courts. Sorry, Catherine, from Shanghai. But even one good thing, of course, is that the Chinese courts are getting much, much better, especially in the big cities. So if you find yourself in court in Beijing or Shanghai, or even, some of the second-tier cities, Hangzhou, they're getting much, much better, but it's still variable. And also, it's a completely alien system if you are not from mainland China. You don't understand how the Chinese court system works. So the solution to most of these problems is to go to international arbitration. So we find that most of the contracts that we deal with that are cross-border and that have a China element will provide for international arbitration. And most of those, although again, kind of getting better, most of those will provide for arbitration offshore China. So in Hong Kong, in Singapore, in London, in New York, in Paris, in the big arbitration centers. Because the investors are still nervous about doing arbitrations in Beijing, in Shanghai, at the CTAC institution. But people again are getting more comfortable with that. And even though investors would say, let's go to arbitration and let's go to Hong Kong, there sometimes will be legal reasons why you cannot arbitrate offshore, that you must arbitrate in China. So for example, if your contract doesn't have a foreign element, it's between two Chinese parties. So even if I'm a big American company, and I have a subsidiary in China, and my subsidiary in China is entering into contracts with another Chinese party, that might not have a foreign element, and it might not allow you to arbitrate offshore. So very often we find that there's arbitration in China, in even what feels like an international type contract. So investors are nervous, and one of the reasons we try to mitigate that risk is to say that we put arbitration provisions into the contract, so if the investment goes wrong, at least you set yourselves up well to try to get the best result, the best way to resolve that dispute. So that is one way.
So I think it's about ambiguity. Chinese law is so ambiguous. Why suffer that from damage? Now I agree with that. Just no choice. In the international companies, we thought everyone would need have come to China. Not really. There's still a lot of newcomers as well. And so when they see they see HSBC, they see Siemens doing such a big scale operation in China. In a sense that that's helps them to understand it is a system that at least a big multinational can operate, can manage whatever. So they can talk to their counterpart, business counterpart. So that helps inevitable. But in terms of it is a cost, it's a hesitation, and a lot of time legal time, professional time are spent on helping people to manage that ambiguity. And as a long-term China practitioner, I think this sort of concepts shaped by a lot of our beliefs. You not only need to accept and tolerate ambiguity, you actually need to embrace ambiguity. And ambiguity actually is, to a large extent, is actually part of Chinese culture. Look at all those poems. So fluid and ambiguous, but how we read between the lines, etc. So that ability to, as an M&A lawyer, to manage that ambiguity is a skill set in itself. It's actually, to some extent, you have, for example, when you have a very pragmatic law system, analyzing all the 100 years of case law to come to an argument to sustain your drafting or your court argument is one skill set. Demanding in its own right, but also the ability to generate options and risk mitigation approach and measures to help a client navigate all the ambiguities you need to go through in transaction is, I would say, is also a very, very demanding testing on lawyer skill at even beyond technical level, I would say. So I'll give you an example of ambiguity. Say, for example, even these days, we were not too long ago talking to some kind of European open-end fund, and one of the requirements that we really want to come to invest in China, but can someone issue an opinion saying that there's a certainty of repatriation of my capital afterward at the end of the day? Why do you come to China? You want the capital and profits back home. Then, as you may know, there is a system, there is a verification process. Chinese government is very good with language. They call it's not an approval, it's a verification. But what is a verification? It's an approval. So there is a lot of ambiguity, and so you need to go through. No one can say that it's non-discretionary, but in practice over the years it becomes non-discretionary. So how do you manage that ambiguity? I doubt anyone can issue a clean opinion on that at the moment. But then law firms need to kind of help manage that ambiguity with the extent that they can do business. And businessmen have to just very good as well.
I totally agree with Justin and Rico as well. China law is ambiguous. And every time you read a law or regulation in China, and actually when you have a case to apply to, and sometimes you just scratch your head, so I know the main issues here, I know the main law, but when you actually apply to a specific issue, you will find there are gaps in between. And China law is not a case law system, so you can try out case law and see, what has been determined before. But sometimes, well, first of all, not all the case laws are, in the public domain, so you probably won't be able to find everything that you need. Secondly, China constantly changes, especially there's a lot of administrative issues. For example, in IP area, we constantly getting Supreme Court interpretations, policies, and constantly you have to update yourself on these issues. So when you actually got trained in the Hong Kong system or the Western legal education, you will find actually quite difficult at the beginning when you actually do legal issues in China and advise on China law, because it's just very different. And that's why constantly the lawyers have to call Ministry of Commerce, call the administrative bodies in China to actually ask the questions, is this the way, really you mean that, after, you apply the law, you think, next issue is this particular issue, you have to actually consult them and ask them. And the legal practice changes all the time as well. For example, in our trademark practice, just one particular law is called undue influence to the society. I would say a year ago, they would say it doesn't apply to personal rights, it only applies to the public interest. But today, they would say, okay, if you try to apply a trademark, which is a famous name of a book, they would say, that's actually undue influence, even though it's not really public interest. So there are a lot of changes, so you have to constantly, in the practice, to update yourself, and by contacting administrative bodies and keep up with the trend. So it is a challenge in terms of for foreign companies to invest in China and to actually need legal advice. It's a challenge for the lawyers to actually make the expectations. To understand the law in China first of all, and then to meet the expectation and manage the expectation of the client.
One of the reasons that English law and of course Hong Kong law has done so well as a law to be adopted internationally is because it provides for certainty of contract. That's one of the reasons English law is used universally in international trade, and Hong Kong law is the same. That in itself, in the Chinese context, causes problems because many international investors will say, let's have this contract governed, if we can, let's have this contract governed by English law or New York law. Because we know that if we say A shall do X and B shall do Z, that the court or the arbitral tribunal will uphold that, because it's what the contract says. And that's one of the big benefits of English law, or the common law system. But that in itself is one of the cultural difficulties with doing deals in China. Because even if you have that contract, and you have that very clear obligation, and you have it governed by English law or Hong Kong law, when things change, the Chinese party will say, yes, but I didn't really mean it like that, or things have changed, let's think about something else. And you find, and this is a big cultural problem that we face day in, day out, because our US client or our English client will say, but the contract says this, so the Chinese party must do this. No, that's not what's going to happen in reality. So I think, again, when we talk about mitigating risk, very often, if you can apply English law or Hong Kong law or New York law, very often that is the right thing to do for your foreign clients, because you'll get certainty in the contract. But you still need to be alive to the realities of dealing with a counterparty who's not trained that way, who has a very different mindset. And you need, I think, as Rico said, you need to be flexible and adaptable to these ambiguities.
Thank you very much. Just when you said there may be different mindsets, I'm just wondering if Because, you know, most companies in China are divided into either state-owned companies or privately owned companies. And is there a difference in dealing with these two types of companies, or do they think quite similarly, or do they think differently?
On the IP side, definitely there are differences. I mean, China's state-owned companies, they are very powerful, they are rich in money. So when they do a lot of IP registrations and enforcement, you can see it, especially when the rights are being challenged in the court. Like you said, all the judges will tell you, basically in China, when you have an infringement case, it's not only, when you look at the case, it's not only based on the merits of the law. You have to look at the policy, you have to look at the political factors. That's the reality. So if there's state-owned company, which is the party of the litigation, you will know, the balance is not really balanced. So it's tilted, definitely. But in terms of IP strategy, I think Chinese government is actually putting a lot of funds and incentives to local private companies to encourage them to get IP rights and giving them tax incentives and cash incentives to help them to build up their portfolio. So I do see there are certain differences there, but majorly I don't see major differences between, in terms of the protection, I can see major differences between state-owned or private-owned companies.
I think on the dispute side, it's quite interesting actually. If you're acting for a private company, whether it's in China or anywhere, very often it's sometimes a bit easier because you're dealing with somebody's own personal interests, personal fortune that they want to protect. I mean, that has pros and cons because, it gets personal, it gets emotional. But just going back to Joseph's point, sometimes they like to pay more money because it's their money you're trying to protect. So the pricing pressures, I sometimes find, are less stark with the private companies in disputes. Because in disputes, they want to pay to get out of the problem. But there's a lot of similarities. What I find is one of the biggest challenges and similarities between the SOEs and the corporates is just the hierarchical structure. And if you are dealing with something where the big boss has signed off or said, this is how it's to be, very, very difficult for you to get any of his or her subordinates to renegotiate or to try to change that person's mind. It's very difficult, and this is the big thing on fees, for example. So if the big boss has said, okay, we're going to cap these fees at $1 million, and then there's a problem and you need to change, you need to renegotiate, nobody wants to take on the big boss and go back to him and say, actually we need to, sorry sir, we need to renegotiate. Nobody wants to do it. And that's the same in SOEs and in corporates. But I do find that, again, Rico, you maybe have a view on this as part of the sort of culture and the mindset. I do find that very often with the SOEs, once you've reached an agreement, it's been signed off, everybody agrees, we've done the deal, we honour it. And I think that's quite interesting. And I see that is more so in dealing with the SOEs than maybe in the private corporate, the private corporates.
I just know who you are comparing PLC state-owned and PLC privately held company. So if that's the case, then experience, my sort of limited experience, when I lived in Beijing, 1.5 years of my life was dealing with one same company. My first and as a Hong Kong person living there, I realized that Hong Kong person is actually different from Netherlands. In terms of culture, thinking is actually, and I realized that actually the same culture, they are, in a sense, when we're working for multinationals, one thing is your client contacts, they are employees, they're officers, they're not the proprietor of the company. So because of that, the mindset is already different. You have the tax director, his power to exert, his job to protect, the legal counsel, the business guys driving his bonus, and it's a check and balance, etc. So you're dealing with a bunch of employees for MNC. But whereas when you're going to a state-owned enterprise, you're also dealing with a bunch of employees. Usually the big same company, they're very smart people, you can imagine. they can come to that kind of niche, very respectable stamp company. They are very smart people and very demanding, extremely demanding actually. And but they are employees, but they also have a bit of like a little bit of an official as well. And the agenda, as far I would say that as a Hong Kong person, it took me a while to understand. So they are actually maybe in another higher agenda that's going on. Their career, how does that look, political, internal, etc. It is a learning process, and I will agree with those who come earlier that some of my local mainland police will be better at understanding some of those nuances and subtleties. For privately held companies in China, I saw a whole range. I saw some big companies whose one boss decides everything, and I also have seen encounter where it's actually very professional, very dedicated, where the middle-ranking or senior middle-ranking officers can make a lot of very important decisions. So, but one thing I find in terms of dealing with them between them, I would say for M&A, for sort of the work I found it easier to dealing with privately held PLC firms, but it's a range. And one thing to say is, from a number of transactions where it's actually privately is big MNC institution or institution MNC foreign dealing with a PLC entrepreneur in a negotiation, in a transaction. A number of times it's actually looking back at the end of the day when you're at the signing table, you really felt that the private entrepreneur he actually won the negotiation because he was his money to protect, and he was while all the tax director and people that were worried about FCPA, worried about other things, he was really getting the bottom line and negotiating with people. So now I think I found our client out negotiated by private entrepreneurs, even the
McKenzie also mentioned about very frequent regulatory changes, and I understand that recently there are attempts to simplify the procedures before direct investments. There was this China merger control. I'm not sure if you're familiar with these regulatory changes, but I'm sure there are different changes in your areas that have been affecting your practice recently. Is there anything that particularly you want to mention, perhaps? Or how does that affect your practice?
I probably jump at this because it's sort of related a little bit more to what I'm doing in terms of sector. That regulation, which was effective on 17th December, like basically liberalizing or easing or streamlining some of the FDI capital conversion process. I think ultimate analysis is not that significant actually. At least it's our sort of analysis. It sort of remove, it basically further dumb put the checking, the verifying obligation, the compliance requirement on the shoulders of the bank, and which is a good thing. It's no question a facilitating factor for FDI into China. But looking in the whole trend from the scenes, all the regulation and streamlining has been happening. I think there is probably a overhype of the impact of that regulations. But putting more the emphasis is on for government to intervene less upfront, but rather increase the entire system on the transparency system, on the kind of commerce, e-com government kind of system where government can actually look at all the banks are on the internet, on the system, and you can look whenever people put the button, you can actually look at what they are doing, and you can always check them out like 30 days later. And banks, and most of them are very careful, and I think it's a good move for government. It's smart, but the impact is not huge.
In my area, the big regulatory restriction is this: if you agree to arbitrate in mainland China, then that arbitration must be an administered arbitration. So for those of you that have studied arbitration, you'll know that there's institutional arbitration and ad hoc arbitration. Institutional is when you have an institution that helps you run the process. Ad hoc, the parties just get on with it themselves. In mainland China, ad hoc arbitration is illegal. You cannot do it. So the big regulatory restriction is this: it must be institutional or administered, but that institution must be a Chinese institution. So that means you cannot have arbitration in China, which is administered by the Hong Kong Arbitration Centre, or by the ICC in Paris, or by the London Arbitration Court, or by the Singapore Arbitration Centre. You cannot do that. So there's a big regulatory restriction on arbitrations in China. That's a problem, because it means in reality that CTAC has a monopoly. Now, of course, there are other big institutions in China, the Beijing Arbitration Commission, the Shanghai Arbitration Commission, but there are hundreds of smaller institutions, which if you're a foreign investor, you really wouldn't choose, because they are not tried and tested for foreign investments. So really all roads really lead to CTAC. And for those of you that have been following the news, you'll see that there's been a big falling out in CTAC between Beijing and other offices or other commissions within the CTAC network. So I think this regulatory restriction is a problem in the long term. It limits the choice of not just the foreign investor, but also the Chinese party in relation to its choice of arbitral institutions that it can choose. There's no signs that that restriction will be lifted anytime soon, but it's certainly not the modern trend in any other big economy. In any other big economy I know that where arbitration is popular, the parties can choose to adopt institutional arbitration or ad hoc, and if they choose institutional, they can use one of the truly international commissions. Now, I don't want this to sound as though I'm saying CTAC is not a good choice. I've had many CTAC arbitrations which I've run, many that have gone very, very well, and actually I think some of the characteristics of a CTAC arbitration are excellent, and that some of the foreign institutions can learn from CTAC on certain things, and I can explain that if anyone's interested. So I think CTAC has its place. I think it's doing very well. It's trying to internationalise, but there are restrictions on the party's choice, and I don't think that's a good thing.
In the IP areas, like I mentioned before, there are constant changes as well. Right now, the copyright law is in consultation. The trademark law is in consultation. And patent law, we actually amended it 2 years ago. Now it's in consultation again. There's constantly change, I think, but then at the same time, because we represent a lot of foreign interests in China, and we actually push for change, because as you can see, every time there's a change, but it's very little change. And the reason is China still wants to protect their own interest instead of actually reaching totally international standard, because they fear actually, the government fears that eventually, if really meeting the same sort of standard in the IP area as other foreign countries, really the Chinese companies will suffer. So that's why even up to today, with all these changes, still haven't reached what we are asking for, and we are trying to go for. Just for example, China, you often hear bad faith trademark registration. It could be a very well-known foreign brand. They didn't come to China for just recently, and they went to China and they found out someone else registered a trademark. And they will actually spend a lot of money try to do the oppositions proceedings, fight in the court. But eventually they found that even with all these procedures they have gone through, they will lose. So end of the day, they are actually negotiating with the Chinese parties to buy back the marks. And it could be really, really expensive. Like for the deals that I've done for clients, it could be $1 million US just to buy one trademark. So what kind of messages sending, to the foreign investors, when you have a legal system like this? So that's why we are still pushing for the Chinese government, but it takes some time.
Maybe this is a good business opportunity, Catherine. We should all be going to register trademarks in China.
That's why sometimes I joke with my colleagues, it's better to be the trademark squatters to make money faster than the lawyer in the law firm.
Speaking of changes, Catherine just reminded about something. Do you think about change? We saw in the firm, sometimes we joke about this, who is our biggest client or indirect client? It's actually Chinese government. They make all these changes. Whenever there's changes, new random work that will be generated. So there's a reason why I said I embrace change.
All right, thank you very much. I think we now have about 20 minutes left, and I do think it will be very, very useful if we have an interactive Q&A session. So if any one of you have any questions directed to all of them or just to one of them, please feel free to let us know. And do also introduce yourself first. Maybe how's your name, where you're from.
Hello, I'm Alex from Durham University. I have one question about arbitration in China. Well, basically, it is often called a private justice because it's not the part of the system of the national judiciary system. And it's usually said that the justification and its legitimacy is because of its international reputation and recognition. So with the changes and restrictions you mentioned, how can the arbitration community and system as a whole can sustain this recognition?
It's a very good question, Alex. You're right. One of the reasons arbitration does so well, it's a private agreement. So you and I can agree how we want to resolve our dispute. And most national laws uphold that bargain. Now remember, wherever your arbitration is, there will be still some supervision. So if your arbitration is seated in Hong Kong, the Hong Kong courts still have supervisory jurisdiction over your arbitration. So if your arbitrator goes off on a frolic and decides on something that was beyond his or her power, the courts can still intervene. So there's always an overarching supervision to arbitration, wherever it is in the world, even though it's a private agreement. So there's still that check and balance, which is very important. But your real question is, if there's this really lack of choice in China, does it undermine the legitimacy? Now the answer, I think, is no, because ultimately the arbitration is decided, the result is decided by the arbitrator or the arbitrators. So if a panel of 3, we are the judges, we are the arbitrators, we will decide. That's not undermined, because the parties still can choose their arbitrator, or the institution can still choose the arbitrator, and that arbitrator is still under a duty to act independently, impartially, and apply the law, and come to the right result. So even though I think it's unfortunate that there is this limits to the parties' choices in mainland China, I think overall it doesn't undermine the effectiveness of the process, or the legitimacy of the process.
Not exactly on your question because of the privilege, but just remind me about on the transaction front, what is here. I could just mention that, and I mentioned this morning with the oral session that whenever we have a choice, as of now, we still go for an arbitration as much as we can. I said it was with no sadness that we should avoid the Chinese court, but as of now, for commercial transaction, we still prefer that. But at the same time, over the last 10 years, we have heard about this saying that China can say no. And a lot of clients and ourselves are saying a lot of no over time. Where, for example, I'll give you an example, like there was a major transaction we negotiated, a hotel transaction in Beijing, where the other side is a big saving company. And our we already considered it with Chinese law. There were 2 points usually in the transaction, 2 points: governing law and jurisdiction. And I was sort of already willing to consider. Okay, I've said Chinese law, we have some Chinese law, but as a swap, in return, we want for an arbitration in Hong Kong, Singapore, and our client already made it as a bottom line. It's a deal breaker. It's a deal breaker because we feel that if we arbitrate in China, even at that stage, there will be potential influence over whatever the arbitration body that, even who they are, we're just not comfortable. So can't make that as a deal breaker, but the other push the envelope. And at the end of the day, the deal was so strategic for the client that they have to accept. So deal with business reality, and although there's a preference, increasingly we are seeing that you may not, on the transactional one, you may not be able to get that. And that's why we are particularly now interested in watching how CTEC programs, because as of now, between CTEC and Chinese law, for commercial clients, they still prefer CTEC. And CTEC, for people in the industry, is really about who's the presiding arbitrator, panel three, presiding arbitrator. It's an important aspect to be addressed in drafting of the arbitration code, as well as when it comes to the dispute situation. So we just hope, and together with all of our colleagues or professional colleagues in China and outside China, we have the Chinese court and also the Chinese arbitration for this continue.
I also echo Rico because the Chinese companies, they had an expectation for arbitration in China, the arbitrators that they chosen can be influenced. So they had this expectation when they actually come to Hong Kong as well. And the company would tell us that, oh, can you influence the arbitrator? I'm like, this is ruled by law here in Hong Kong. It doesn't work the same way. So I think that's why I totally understand the Western companies, when they have a choice, they would certainly choose arbitration outside of China in order to have a fair, decision. But unfortunately, on IP issues, for commercial IP, like licensing issues, it can be arbitrated. But for infringement issues, you still have to go to court. It's not going to be arbitrated. So, we stuck with the court in China.
There was a great case this year in Hong Kong. People might have read about it, called Kenai. And it's a great case. It was an arbitration in China. And during the course of the arbitration, which is very common in China, the arbitrators decided they would act as mediators. So they were sitting as arbitrator, but they thought during the course of the arbitration that they would try to broker a deal and try to find a solution with the parties. Very common in mainland China. And actually, if for common law lawyers around the room, everyone thinks this is terrible, and how can an arbitrator or how can a judge act as mediator? I'm quite relaxed about it. I've seen it in practice. It can be very, very effective. And anyway, it's very common in China. Very common. But what was very interesting in this case is that the arbitrator, who decided to act as mediator, went out for dinner with one of the parties on his own, without the other arbitrators and without the other party. So he just went for dinner to the Shangri-La Hotel. I can't remember which one. It's Xi'an, I think. And they had dinner, very nice dinner apparently, and this arbitrator said, okay, why don't you settle for X dollars? Come on, do the deal. And anyway, the deal didn't happen, and the tribunal then went on to render an award, and the winning party brought that award to the Hong Kong courts to enforce. There were assets in Hong Kong. So the Hong Kong courts had to decide whether this dinner at the Shangri-La, where the arbitrator acted as mediator, undermined the whole process. And I think the Hong Kong courts got it right. The Hong Kong Court of Appeal said, if you have agreed to arbitrate in China, in mainland China, you have to accept the rules of the game. I call it the when in Rome case. So when in Rome, do as the Romans do. When in China, if you've agreed to arbitrate in China, and arbitrators can act as mediators, you have to accept that. And actually, in China, this arbitrator did nothing wrong. He was acting as mediator. He went for a dinner. There was no suggestion that it was improper. He had a dinner, he tried to broker a deal. The deal didn't happen. When in China, that's acceptable. And the Hong Kong court said the award is fine, and they enforced the award. So, if you're not comfortable with that, that's another reason not to arbitrate in China. But actually, arbitrators acting as mediators can be very effective with the Chinese party, because the Chinese party looks up to the judge, looks up to the arbitrators, and if the arbitrator starts to twist their arm and say, come on, you need to do this deal, it can be very effective, much better than me doing it as a lawyer for the other party. So, but it's very interesting that the Hong Kong court said, no, when in Rome, it's fine. I mean, there's always this, on Alex's point, there's always this level of supervision. So if it overstepped the mark and had been contrary to Hong Kong public policy, so if at the dinner somebody had given the arbitrator a big brown envelope packed with cash, then the Hong Kong courts would not have enforced the award, because that would have offended the public policy of Hong Kong. But in this case, the dinner in Shangri-La did not. So it's quite interesting. But it's also a good example of the Hong Kong courts being very pro-arbitration, in upholding the arbitration process. Because if the parties want arbitration, the Hong Kong courts will try their best to support it.
I think it's time to say good afternoon. My name is Zheng from Taipei. I have two questions for Justin, still for you. Regarding arbitration, like, even though you get an award from offshore arbitration center, and if the access is in China, you still have to enforce it. In China, you still have to get the support from local courts. So, like, the local protection issue is still there, or how can you solve it? And secondly, like earlier this morning, Joseph mentioned a very interesting case, King and Wu and Madison's. King and Wu, Herbert Smith had Freehills together. Or if you say, of course, you think it's a business secret, just let it go. Thank you.
Okay, I think I'm on camera, so I have to be very careful how I answer these questions. The first question, which is, it's a very good question, and we get asked it all the time by clients. They say, okay, you've sold me arbitration. Rico's told me I have to have an arbitration clause in my contract. But at the end of the day, if I have to still go and enforce against the Chinese party and they refuse to pay, I'm still going to end up in the Chinese courts. So what's the point? Well, there's two answers. One is that if you get your arbitration award from Hong Kong or Singapore or another country which has signed something called the New York Convention, I think a lot of people will have heard about the New York Convention, then, and we don't need to go into it this afternoon, but it means that you can take that award and take it anywhere around the world, and and enforce it around the world. And many Chinese companies don't just have assets in China. They have bank accounts in New York, they have assets elsewhere. And you can take your Hong Kong award, you don't have to enforce in China all the time. So that's one advantage. Whereas if you go straight to the Chinese court, or even the Hong Kong court, you might not be able to take that judgment around the world because there's no equivalent to the New York Convention. But if you do have to go to the Chinese courts, are you not still in the same problem? That's your question. It's difficult because if you have to enforce in China, you usually have to, you can't just pick the very trustworthy Shanghai courts or the very trustworthy Beijing courts. Very often you must go to the local court where that asset is. And very often you might be trying to sue the big SOE or the big corporate in that town, in that place. So actually they might be responsible for 20-25% of the economy of that local city or local town. And the courts are not going to be very pleased. So it's a problem. There is protectionism. But the Supreme Court, the Chinese authorities did one very clever thing recently. They said, if you take your arbitration award to the court, and if that judge refuses to enforce it, that judge must report that refusal up to the higher court. And in one very, very clever move, it has significantly reduced the number of occasions where the judge will do something wrong or will be influenced because he has to tell his boss. And it's been very clever, very successful, because it means that the local judge in that local court, which is, maybe got some sort of protectionist mentality and doesn't want to enforce against the local Chinese company, he has to think very carefully because he has to tell someone else. He can't just say no. So that's been very clever. Okay, your second question, why did we do the merger? I shall answer this, Joseph. Look, it's very simple. For my firm, my old firm, Herbert Smith, Asia is the place where it's at. We're all concentrating on Asia. China is a hugely important market for any international law firm. It's a very important market for anybody, anywhere in the world. And there are so many emerging markets in Asia. And for Herbert Smith, we've been in China, like Eno, we've been in China, we've been in Hong Kong since 1982 for 30 years. It's a very significant bit of our business. And doing a merger with a big firm, Freehills has an excellent reputation. They are one of Australia's leading law firms, in particular in the areas which interest us: energy, disputes, to name just two. So what they bring us is very big economies of scale. So overnight, we become the largest firm in Asia Pacific, the 8th largest law firm in the world. And we felt that that was an important strategic move because it helped give us absolute strength in Asia Pacific, which we felt was an incredibly important part of the world. And it gave us economies of scale. Like the Scots, the Australians like to move around, and we're opening new offices. This year we're opening, well, in the next 12 months we'll be opening in Seoul, we've just opened in New York, we'll be opening in Africa. We need people to help staff those offices, and the Freehills body, the mass, will help us staff those offices as well. So lots and lots of reasons, lots of synergies between energy, our energy base, our disputes base, and geographically important. So I think that's the answer, but I didn't bring my cheat sheet about the merger. British chairman, but somebody that would be very neutral and would give you an international or a very neutral process. And that means all the risks of, or many of the risks associated with CTAC or with arbitration onshore China, a lot of those go, because actually it's that chairman who makes most of the decisions along the way. So there are tricks, there are tricks.
Again, I don't want to sound one-sided, as I mentioned this morning. It's not all that even our clients have had their fair day at Chinese court for complicated cases. So it's just about that ultimately is that necessary degree of trust. Country, system, company, individuals. One thing that we really take a lot of effort and time to build up is trust. And if that trust is not established and or violated, it takes you a long, long time to establish. And it's not, despite all the improvement, it's not up to that level. And when people have a choice, people choose something that they feel is more comfortable. It's not that easy. I don't want people to get away from this room to say that it totally sucks. No, it's not true. I don't want to get that.
All right, thank you very much. I would like to invite Jonathan to now present souvenirs for our panelists. So thank you very much once again for coming. And thank you, Catherine, for your insights in IP law. Rico again, thank you very much. Now we will be having lunch very soon, but at this point I would just like to let you know that Mr. Alan Shipman and Ashley So from Skadden has joined us today. So they're right there and they will be joining us for lunch. So you'll be seeing them later as well.